Any common of yen shasia enfi the course enra committee omampanyi eseti anase constitution eseti ye se enhwe na entumi enhwehwe niememu efa ye maame Justice Torkonoo meka Justice Gertrude Araba Esaba Saki Torkonoo ne issue na ebeto odwa no per article 146 a ehye omampanyi ene omamaka nyina se yenye bibisa because petitions bi aba no ne nyina etu etwa the tintin titia ne se omampanyin se asem no de esia na esie mame Gertrude Araba Esaba Saki Torkonoo onfa na djuma ento ho na onkotena baby na ontoa na djuma so pese oye eno na babeto dwasisia ba ne ye bedi nkomo ye ne liars titi wofo bedi nkomo na afi ya hwe de ekọ ene de eba omonkyere ase na afi hu de ekọ ne de eba na lawyer bedema ewo my line no so madam fu ye pa ye no ending nkomo law lecturer CAF University na ye no ending nkomo eba sei sa na omo an ye be komo ne no medi nkomo no ma kyerkyere ne ma ne yesua de hu de ekọ lawyer, good morning and welcome to Kessben Marching.
Good morning, my good friend Kojo. How are you?
I'm okay, and how are you doing?
The Lord is good to us. I am very fine.
Amen. Now I think I have to start greeting you in tree so you can then learn it faster. Bibia boko there. Eradia don't bibia fine. I think the tree you're doing well with the tree now.
Yes. I'm coming up small.
We thank God. Now, lawyer, when you hear this, and I read, now therefore, know ye all men that I, John Dramani Mahama, President of the Republic of Ghana, in pursuance of the said Article 146(9), do hereby remove the said Chief Justice Gertrude Araba Esaba Saki Torkonoo from the office of Chief Justice and Justice of the Supreme Court with effect from the day hereof. In witness whereof I have hereunto set my hand caused the presidential seal to be affixed at Accra this 1st of September 2025. When you hear this, what comes into play?
Straightforward, I go back to my law class, and it resonates with what we write at the law school. The president sought to write like one of us in the law school, hearing, and all those kind of words. They are the kind of technical words that are used over there. But then again, I think that because he was acting on the dictate of the Constitution, that gives him that power. So he was trying to exercise the powers that the Constitution has given him. That is why he has used those words. So it's just it's nice to see how he coached the whole thing, and that he is also, as it were, trying to use the powers that are conferred on him by the Constitution. One thing that can be seen is that, of course, as people of Ghana, we need to be, as it were, to be proud of ourselves, because we have accepted the Constitution for ourselves, and that Constitution seems to be followed by all and sundry, and that the president has again exercised his powers given to him by the Constitution.
Lawyer, when I was reading, one thing that really came to notice is the removal as Chief Justice and Justice of the Supreme Court. One want to ask, if taking Justice Torkonoo out from the bench, is it first off powers from the president that can do that, something that she has worked for? I mean, she is, a lawyer, probably a judge, and then we are combining the two as Chief Justice and then taking her from the bench. Does it really connect well?
To be fair, and also to be in line with best practices in the world, I think that should be the fair thing to do, because one who is not qualified or who have done things that have occasioned the person's removal from the high office of the Chief Justice, I don't know how that person could be allowed also to be the justice of the Superior Court. Because one thing is that it is from that Justice of the Superior Court that gives you that leverage to become the justices, the CJ.
Okay.
Right. So if you are disqualified again, and it's as a result of stated misbehavior, and again for you to be given the appointment as the justices of the Superior Court, you must be a person of high moral character and certitude, and that you are of sound mind and those kind of stuff. So again, we have to look at the qualifications of a person to become justice of the Superior Court and see whether being held to have misconducted yourself, you could still be qualified to be the justice of the Superior Court, and that is the government of the whole matter. And I think for me, in my own thinking, I don't think that somebody who has been removed as a result of stated misbehavior as the Chief Justice of the Republic should be allowed to continue as the Justice of the Superior Court of Judicature. And again, we must be very careful, because aside even this constitutional lens I am trying to look at this from, we need also to look at it from where do you think that somebody who has become the head of the judiciary, who was leading the judiciary, now being removed in this manner, even if it is allowed that she should continue to be the justice of the Superior Court, she may have that ground or that, let's say, the ground to stand there to be the justice of the Superior Court. And again, I think that person may not be. Aside the fact that once you are being removed as the CJ, you may not be qualified to be the justice of the Superior Court. I think again, morally to that, she may not have that power or that courage, or so to say, to continue to be the justice of the Superior Court.
Let me ask you this. Many people have said, from the law point of view, that they had felt or expected the Chief Justice Torkonoo to had resigned. I mean, before this thing came in. Do you share the same thing?
I think to some extent, yes. I shared, and I even mentioned some time ago on this your August show that I thought that maybe the advisors could have done her better by maybe asking her to stop all the courts running here and there for those cases at court, because I thought again that if it's going to the ECOWAS court and those kind of stuff, it's a way of saying that our judicial system is not up. And if the judicial system is not up and you are running even outside Ghana, the question is, what were you leading? She was the head of the judiciary, and now you are now the head of judiciary, and they are taking judicial process against you, and you are now running to other parts of the world for adjudication. The question is, does it mean that the judicial system of which you were the head was not working? Right, and that is, is it not working? Because if it was working and people who come to you get justice as is demanded or is to be done, then you ought to have also received same justice when you have problems. So to the extent that she has to run, yes, someone will also say that is her right. She has the right to go to those places. But frankly speaking, for me, yes, she was exercising her right, but the right she was exercising were also exposing the weakness in our judicial system.
Okay.
Because this is a woman who was the head of the judicial system. The judicial system of which you were the head, you are now running away from it. So it is only going or telling us that maybe the judicial system of which you are the head is not working well. And that is why you are seeking remedies from other courts or avenues which are outside your jurisdiction. So a lot of things have happened for which I think that maybe the advisors might have done better in that regard.
Well, I have heard former Attorney General Ayuko to say evidence of wrongdoing to justify her dismissal is not there. I have heard the issue between policy and the law. Now, let's deal with the policy and the law. The policy, I mean, as in the judiciary, in terms of traveling and all those things, versus the law. Because when you watch what the committee submitted, they keep saying that whatever happened cannot be justified in law or policy. But here is the case: a former Attorney General is saying that it is the policy by the judiciary that was used by the Chief Justice in terms of traveling, in terms of per diems and all that. I mean, the contradiction there. Which one do we stand for?
We go for the law.
We go for the law and not the policy.
The policies are just to guide the conduct of maybe a particular organization.
Yes.
But aside that one, there are laws that supersede the policies. The laws of this country supersede any other. Whatever policy that we have must be in consonance with the Constitution, which is the supreme law of the country. So if there is a law which is inconsistent with the provisions of the Constitution, then that law ought not to be in our good books. So the first question we have to ask ourselves is, what are those? And if I listened to him very well, he mentioned one thing which is in line with the Constitution, which is the fact that the judiciary, when it comes to their financial matters, are independent. That is correct. But the question again we need to ask ourselves is that independence sacrosanct? You cannot seek to ask any question regarding how the monies are being spent. Nobody can look at it, even the president, or even it's like my question is, if there is misappropriation of funds, does it mean because they are independent, they should allow them to do whatever they are going to do? Again, we have something we call the discretionary powers, which is also grounded in law. But even those discretionary powers are supposed to be exercised within the dictate of order, the remit of the law. So nothing is left without check and balances. And the Constitution has been made in such a way that at any point in time, there are checks and balances. And for me, again, I think that because we do not practice pure separation of powers, these checks and balances are there to curtail the abuse of these powers that are conferred on individuals who occupy those positions. Right? Again, another thing that I have seen to be a bit problematic is the wording in Article 146, Clause 1.
Okay.
Where some of the words there have not been given judicial interpretation. And the framers of the Constitution could not affect their mind to have defined those words.
Okay.
For me, which it has left the Constitution too vague, or the provisions of Article 146, Clause 1, very vague, because we don't know what amount to gross misconduct for which a Chief Justice or Justice of the Superior Court could be removed. And leaving it that way is not enough. So as a people and as a Constitution that is capable of growth, we need to also adjust. We need to amend those provisions to reflect the right thing, so that we don't leave the Constitution to speculations. Because now most of us are just speculation as what ought to have been, what to be the ground for the removal. Because they only stated there that it must be a misconduct, And what amount to that misconduct, we don't know.
Exactly, lawyer. And that leads me to the other question that I wanted to ask, and that is exactly where you've gone to. Because if you've been able to identify that space, then it tells you that subsequent governments, I mean, until that article you quoted, 1461, is something is done about it, then the perception is that any other government that comes in, and I'm not comfortable with the said Chief Justice appointed, what it means is that I can institute and then go through the same process, come up with a certain misbehavior, and then I can use 146, set up the committees, and then I remove him or her from there.
And that is why, I think that the president, when the NDC government came to, or I think they have commissioned the constitutional amendment or review committee.
Yes.
So I think that committee needs to be very fast with coming out with the sort of amendment that needed to be done to the constitution. The only unfortunate thing for me is that before that will be done, she might have already suffered it because this is the law as it stands now. But I think going forward as people and having known some of these discrepancies in the law, we need to look at them and then amend them to reflect the state of the law. Because otherwise, for me, again, as constitution as it is of course a sacred document, a sacred testimonial document that needs to be protected at all times, and so it should not leave room for speculations.
Because it's I read somewhere another private legal practitioner saying that he sees it more political than law, and anyone who defends it is either complicit or ignorant.
It's unfortunate that I can't come on a platform like yours like this, and in my criticism of maybe a work done by a colleague, I will refer to that colleague as an ignorant person. That again, for me, I think that it is uncalled for a colleague to say other colleagues are ignorant of the law.
Okay.
We are all giving our fair views of how we see the law to be, and as any constitutional law class, no answer is actually wrong. No answer is actually wrong. And so if no answer is wrong, then no answer is supposed to come from what? An ignorant person. That is his perspective of the law. And so we can judge, but to label colleagues as ignorant, that is unfair comment. And I think it should not be coming out from learned people like ourselves. So it is most unfortunate because that is somebody's perspective, and that cannot be said to be ignorant. You can't say that. I can't come here so that, yes, I disagree with what he said, but I can also come and say that if he says so, then he is ignorant. No. That is not the way we have to go. We are brothers. We all sat in the same school. We were taught by the same people, and so to label your colleague as ignorant because he has seen a matter in a different perspective. So does it mean that all the people in the art committee are also ignorant? Is that what you sought to say?
Very interesting. Now, I want to come back to the policies again with regards to judicial service and all that. Now, Justice Torkonoo becomes the first Chief Justice who have gone through this particular procedure to see her removed. It serves as a lesson. It's going to serve as knocking all the loopholes, like you really brought the Article 1461, which you said that it is too open, it is not really specific to certain things and all that. Now, Ayuko, to us, former Attorney General, also comes back to say that, for instance, the committee deliberately ignoring established policies. Now, would you want to see judicial service go back or look into the policies again to really shape it well in order for it not to be used against any other person again?
Well, that again, I have not had the benefit of reading that policy statement.
Okay.
And so I wouldn't be able to talk to it specifically. But if there is a need for a law to be amended to reflect the right things, why not? It can be done.
Okay.
The laws are made by human beings, and they are supposed to achieve certain goals at the end of the day. So at all points in time, the question we ask ourselves is whether those goals are being achieved. Now, if they are not being achieved, then what do we do in order to achieve those goals? So at any point in time, those are some of the questions that we ask ourselves, and we go by that by maybe amending. And that is why every law has that amendment clause in it, where at any point in time, when they see that the law is no longer serving the purpose for which it has been made, then it can be amended in order to serve the purpose. Laws are not made in vacuum. They are actually made to solve certain problems. So if the law is not solving the problem for which it has been made, then it becomes absolute. And for that matter, that law needs to be changed.
Lawyer, are you seeing too much of political interference when it comes to the judiciary?
This is a very dicey question, of course, because we cannot separate totally judiciary or law from politics. But we need to tackle it with caution, because when it is too much seen to be politicized, then it will also go a long way to spoil the goodwill we have so far as a country of good governance, country that is practicing the law. Because again, politics to some extent has destroyed many societies. Politics is a good tool, but if it is not exercised well, can also destroy the society. So we have to be a bit careful when we are trying to maybe use the two. Yes, the two go hand in hand, but we have to exercise restraint, patience, and restraint when we are dealing with them, in order not to ruin all the accolades that we have received so far from the international community.
Will this decision taken give the judiciary system of this country a different picture altogether by the international community? Do you see something like that?
I don't think so, because once it is by the dictate of our constitution, so be it.
Is it a fact that we as a country, we are setting some very dangerous precedent within the judiciary? I mean, the chances of other potential and competent judges who will become CJs, will they have would they be comfortable? I mean, in this situation, knowing very well that their colleague had gone through this?
No, I don't think that. I don't think that there should be any payday for anybody, where it must be seen that maybe one thing is not done right. So until then, all I felt we need to do as a country, as it stands now, is to look at some of those vague provisions of the Constitution and amend them, and that is good to go. Because the Constitution that makes way for the removal of the Chief Justice has also had mechanisms for the protection of the CJ.
Okay.
Yeah.
I see. Now, what do you make of this one before I let you go? One of the issues that was also raised was a breach of provisions in Article 295A and B of the Constitution, talking about a transfer she did. I mean, in a manner that was not good. One Mr. Baden as a staff of judicial service. I don't know whether you heard that one too, and what really the 295A and B says in the Constitution.
Well, we may have to. Do you have the Constitution with you?
Not at the moment, but I will let production get it for me.
Yes, so that we read the provisions
exactly.
of it, and then we can give correct interpretation of it.
Okay.
I get it.
Looking
for my Constitution. Let me see.
So that we can really get it, because the committee also stated without fear or favor that the Chief Justice unjustifiably breached the provisions of Article 295A and B of the Constitution of 1992 in the way and manner that she transferred one Mr. Baden, a staff of the judicial service. That is one of the things that they said that it is amounted to also another misbehavior. I mean, from Justice Torkonoo in the case that were determined by the committee. So indeed,
Has your production gotten the Constitution?
No, Richard is on, so maybe we might get it later on. But if you have also not gotten it, I think that all these ones are amounting to misbehavior. I mean, that's what they're saying. Which for me,
and that is where I'm telling you that is the problem for me, because what actually is the misbehavior the Constitution contemplated, nobody knows. You see, so it's like everybody in his own definition will tell you what amount to misbehavior. Right. So, and the constitutions are not supposed to be in that way, where it will be so vague, and then it will be too vague, and you cannot be able to pinpoint what one at any particular point in time means. We need to know exactly what one particular, at any particular time when you say something is like this, the Constitution should define that, and so that there won't be any need for speculation. So as it stands now, we should have known directly what amounted to what misbehavior or stated misbehavior in the Constitution. But it has been left without the definition.
Oh, it's interesting, and I like the position you've made. I mean, in terms of putting too many things under misbehavior, and then we use that in making sure that a certain Chief Justice moves out and all that. Clearly, it's some way. For the nation as a whole, and if care is not taken, it becomes more or less like politics and subsequent governments are taking advantage in saying that, listen, when I come to power and then you are in there and I don't like you, I feel I don't like you, I move you. The same applies to Electoral Commission. We'll go through the same processes again. Somebody brings a petition and then you go through it and we are like, it is misbehavior. We just have to let the person go, and then we'll do that. Then the next 8 years, 4 years, we'll come back again, and then subsequent governments will also come, do or act on the same manner. And where will the country end if we go through all these processes?
Again, that is
very interesting.
That's very sensitive, and that is what I said earlier on, that the Constitutional Review Committee needs to up the game. It is only good that at this point we have such a committee that is looking at how the provisions of the Constitution needs to be updated, rectified and amended in order to reflect the current positions. And so, yes, we have an opportunity. I don't think there is any call for alarm. There is opportunity that is giving all of us as constitutional students to actually also present our papers to the Constitutional Review Committee, so they can also incorporate it into whatever proposal that they will be bringing up. But again, I think the Constitution has lived its expectation. It has taken us from 1992 up to today. That is enough. So we cannot say that our Constitution is not good. I think this is a document that has actually helped us as people to live up to this end. And so at this point, if there are certain loopholes or lacunas, we just have to fill those lacunas in order for us to continue as a country.
Very well, very well. So, what will be the next thing? As government had gone through the process, President has done what they need for. What happens next to the judiciary? What will be the next process?
No, so now as it stands, then we need a substantive Chief Justice. After she was suspended, one senior justice of the Supreme Court was named to be the acting Chief Justice. Now we cannot have a forever acting Chief Justice, so it is time for us to also, as it were, look for the substantive Chief Justice. So I think that is the next process, and we take it from there. But again, let me also just mention this, that again, another lacuna of the law, if you look at the provisions of Article 146, is the fact that an administrative body seeks to be given final adjudication powers. Mm-hmm. You know, the committee, the Constitution in Article 146 made it that whatever recommendation of the committee that was formed, then the president needs to act on it. And there is no other provision as to if somebody is aggrieved by whatever decision is made by the committee, how next or what next will be, what is the other remedy that will be available to any party. But that is again another problem with the Constitution, because it's like, yeah, we know that the Constitution has given the final adjudication powers to the judiciary. So it is the court that can bring finality to all matters in this country. But when it comes to the removal of the Chief Justice, it says that whatever recommendation of the committee, the president must act on it, and that is all.
Educators, so continue, sorry.
So as it stands now, I don't know if the Chief Justice is aggrieved what she should do. But again, for me, again, as a lawyer, I think what I can advise, if she feels at any point in time that something has been done unconstitutional, she can go under Article 2(1) and Article 130 of the 1992 Constitution in order for court to as it were, crash whatever decision has been taken by that committee. So the committee may not be final. We can go under 2(1) and Article 130 for that decision to be quashed. So it may not be too much a big deal.
Oh, okay, very well. Educators, so some of this is when as it happens, like we have now. Is there an opener? Is there a space for Chief Justice Torkonoo to come back to say, I want a redress of this, or it is over? I mean, there's nothing that can be done again.
Oh, there are provisions of the Constitution that she can, like I said, take advantage of. Okay. Article 2 and Article 130 are there. So she has other means of addressing issues pertaining to her removal.
Oh, okay. That's fine. I was just reading the Article 295, 2A and B, and I think it needs further explanation. Maybe we'll come back to it at a later date. But A says that a reference to a holder of an office by the term designating his office shall, unless the context otherwise requires, be construed as including a reference to a person for the time being lawfully acting or performing the functions of that office. And then B says references to the power to remove a public officer from his office shall be construed subject to clause 4 of this article as including references to a power conferred by any law to require or permit that officer to retire from the public service. I think it's referring to some other clauses which needs a deeper, reading and understanding on it. So, but basically that is what the Article 295 says here.
I think, Gojo, we can have another time where we will look at it. Sure.
Thank you so much for joining us, and I'm sure, sir, pretty soon we'll get back to you as the discussion moves on. Thank you so much.
Thank you so much also for having me.
Medasipa.
Yes, Medasipa.